All right, with this, we'll move to the next segment on the conversation. Now, the Ugandan government is proposing a new law that will permit military courts to try civilians for certain offences, despite a 2024 Supreme Court ruling that deemed such practices unconstitutional. Notably, opposition figure like Kizza Besigye, previously detained and charged in a military court, could again face military prosecution under the proposed legislation. Now, Justice Minister Nobert Mao stated that the draft law awaiting cabinet approval would define exceptional circumstances under which civilians could be subjected to military jurisdiction. Critics contend that this could undermine judicial independence and be exploited to intimidate political opponents, especially with the 2026 election approaching. Now, in a democratic society, should the military have the authority to prosecute civilians, or does this risk eroding civil liberties and the separation of powers? Joining me on the conversation right now, I am joined by Wanda. He is managing partner, Matsiko, Wanda, and Arinda Advocates in Kampala, Uganda. Thank you so much for joining me on the conversation, Samuel.
Thank you so much for hosting me the conversation. Good to be here again after a long while.
It's a pleasure. Now, Samuel, to begin with, right? Remember in January 2025, Uganda's Supreme Court declared military trials of civilians unconstitutional. So how does the government justify introducing this particular legislation, that appears to contravene with this ruling?
Thank you so much. As you said, on the 31st of January, this very year, the Supreme Court affirmed what the Constitutional Court had said in about 5 cases from 2016 till this year, where they declared that any trial of civilians under the General Court Martial was null and void and unconstitutional. It went ahead and said that even a trial of soldiers for offences such as capital offences, which would not ordinarily be tried in civilian courts, was unconstitutional. And the Supreme Court based its judgment on a few things. One of them was the right to a fair hearing. The other was the independence of the judiciary. And the critical part on the fair hearing and the independence of the judiciary was the people sitting in the military tribunal were not educated enough to understand or dissect what the law is, and therefore automatically would have a miscarriage of justice. With regards to the independence of the judiciary, we all know everywhere in the world the armed forces are headed by the commander-in-chief, and the commander-in-chief is normally the president of the Republic of Uganda. So if we are to have judicial officers, in brackets, who are under the command, the commander-in-chief, and they are serving soldiers, then it becomes hard for them to have their independence, but rather follow the dictates of their commander-in-chief. Those were some of the grounds why the Supreme Court declared a trial of people, now not only civilians, but even soldiers, in the General Court Martial unconstitutional.
Okay, now you're also saying that, President Museveni arguing that military courts are necessary due to inefficiencies in civilian courts is not part of the issue, because we would love to know what specific shortcomings in the civilian judiciary is the government aiming to address with, passing it to the military, passing it with this law.
You see, when President Museveni says that civilian courts are not efficient, and that's why he wants to have the military tribunal, that takes us back to independence, because he knows he can direct a soldier to do what he wants them to do, and not necessarily them following what the law is supposed to be. For us, we don't believe that this law is intended to cure anything which the civilian courts is not doing. We know it's intended to persecute political opposition, politicians, We are headed to 2026 where we're going to have elections, and we anticipate that several people may be arrested and detained for such a long time without any trial. You may be well aware, after the 2021 elections, we had people who were arrested, and to date, their trials have never kicked off, and they were in the general court martial. So the purpose of Mr. Museveni insisting on general court martials or military courts is to ensure that we can have it as a tool to persecute opposition politicians so that they are kept away from the public and participating in politics.
Okay.
If you may recall, last year, the government had come up with a bill to amend the UPDF Act, and among them was not an issue of their jurisdiction. It was actually creating only the appellate court that could allow someone to appeal from then to the civilian courts. Now, when the Supreme Court declares the general court martial constitutional, based on those grounds I've stated earlier, now the same government wants to come up with a law trying to cure what the Supreme Court indicated could be the problem, one on the qualifications of the chairman of the military tribunal, and then also their independence. But this is not solving the problem. And actually, our constitution under Article 92 prohibits legislating to defeat a judgment of court. We've had scenarios before where the Police Act, sections of the Police Act were declared unconstitutional, and government brought back the same sections under the Public Order and Management Act. And the brave Ugandans still went to court, and the same section in the Public Order and Management Act was declared unconstitutional. So we are in that situation where the government is trying to legitimize what has been declared unconstitutional, but again, it's to us, it's again overthrowing the Constitution itself.
All right, Samuel. Now let's just quickly take a quick break. When we come back, we'll definitely continue this conversation. Stay with us. Now, welcome back, and thank you for staying with us on the conversation. While we were discussing how the Ugandan government is proposing a new law that will permit military courts to try civilians for certain offenses, you know, even despite the 2024 Supreme Court ruling that deemed such practices unconstitutional. Now, we've been speaking with Samuel Wanda, a managing partner with Matsiko, Wanda and Arinda Advocates in Kampala, Uganda. We have joining us also Daron Bartlett. He's a journalist in Kampala, Uganda. Thank you for joining us, Daron, and thank you for staying with us, Samuel.
You're welcome. Thank you. Thank you.
All right, so let me move the next question to you. We'd generally just love to have your thoughts and pick your brain on, you know, this particular issue, Daron. What are your thoughts on this? Do you think that it is a right move for the military courts to try civilians?
I would say no. That is my opinion. I would say no because we already have courts that are available to handle cases of civilians. If you look at the security structures in Uganda, both the police and the army already have their own disciplinary units that they used to discipline the officers who are committed maybe indiscipline cases in there. But to handle civilian matters was coined from a point of from what if civilians are involved in cases such as treason, they involve themselves with rebel activities, because you need to understand where the government came from. There were civilians who went to the bush and then became soldiers, they became who they are. Now, to deter some of those things to really occur, that's why they brought up some of these laws to deter that kind of habit. Because there are times when we see civilians have gotten themselves into guns. The leader of the ADF was arrested, was a civilian before he became a leader of a rebel group that is based in Congo. Now, some of those things, some of these laws were actually put in place to deter some of those habits. But do I agree that they should be charged there? I say no, because the courts that we already have that are available also handle cases in relations to that. Like I just talked about the leader, the former leader of the ADF, is being tried in civilian courts. And so many more that are out there. So if you look at the way or the decision or the line between what can be charged in the court martial versus what can be charged in civilian court. It's a very gray area, and it's not really much defined, and that's where you hear contests or protests from human rights activists, legal personnel. They come out and say, because of that gray area, you cannot take civilians into the court martial. So I would say, in my opinion, I would say no, because of that gray area.
All right, now speaking of gray areas, Daron, Justice Minister Nobert Mao did mention that, the draft law would define exceptional circumstances, in quote, exceptional circumstances under which these civilians could be tried in the military courts. So can you elaborate or help us understand what these circumstances entail?
So, to be very frank, we don't know much that was discussed by the ruling party when they convened to discuss this proposal. Of course, there was already a bill that was in Parliament that they were going to pass, and then we drew it to amend to add some of other proposals, including those exceptional ones or gray areas that we are not very sure about. But the ones we are very sure is that the hierarchy in the military court must be at least headed by someone who is at the level of a high court judge, and also that the people who sit at the panel or their bench at least must have a training or at least be a lawyer. They must have the legal training behind that. Previously, it was just appoint someone to go and sit or in the court martial and do it. But now when it comes to cases, and this is I'm just going to go in here and there of what I think it will be, because as of now we don't know what those areas or particular cases or standout cases that they want to look at. But I would go for things like rebel activities. If you find yourself in a position where you are mobilizing against the government, that means you have an intention to overthrow the government, you're using arms which are, according to the UPDF Act, are only made for the security organizations like the UPDF. There are some armory that cannot be used by any other security organization apart from the UPDF, that is the nation's army. So if we are going to get involved in issues like rebel activities, I would say maybe those ones can be tried under the court martial, but not, or maybe even terrorism. But also the issue with terrorism is that it's usually not committed by people who have an intention to overthrow the government. It's usually committed by, I would call them civilians, who have an intention to put fear into the people. And those ones are tried actually in a civilian court. That's the most interesting thing. But in my view, I would put terrorists and rebels into that category.
All right, I've got you on that. Now, let's move to Samuel. Now, Samuel, we've had opposition leaders like Kizza Besigye, Bobby Wine, who have actually faced charges in military courts. But Human Rights Watch has actually criticized also these military courts for lacking independence and impartiality. Now, can the government plan to ensure fair trials for civilians in military courts, even though, Daron did say that he thinks the idea behind, the whole military courts is so that the president can have a say and, from what I get from what he said, stifle dissent as well?
You see, from the word go, the president has always wanted to have control over all institutions. Now, institutions, we are to see the entire bill, which will be presented tomorrow, but we want to see the security of tenure for the chairperson and the members of the military tribunal, because now their independence erodes even in their security of tenure. Currently, they have been serving a one-year term, which is renewed at the discretion of the commander-in-chief or the military council. Now there we cannot have any kind of independence. But also, as we've said earlier, for anything where it's a soldier or someone in the service force, and they report to the commander-in-chief, technically, legally, and by training, they are bound and they are trained to respect and obey lawful orders or commands from the higher authority. Now, there is no way a chairperson of the military tribunal or the judge, in the event they create a division of the High Court, a military division of the High Court, a judge who is a soldier and in active capacity as the soldier will refuse to respect the command from the president. Now, the president and his cabinet really want to use the military court, and they are bringing this amendment to entirely persecute opposition politicians to their advantage and to the detriment of all other civil liberties. You can't expect any fair trial or independence of the judiciary or intervention of the court where the commander-in-chief is directly appointing and people are under his command. We've seen him blast even the civil courts where they have gone ahead to issue judgments which are against his wishes. Even in the January 31st Supreme Court decision, went ahead and blasted them and only praised the few who had recommended that the military tribunal courts can only be reestablished if they follow the Constitution. So you can see his mind is in purely having an institution which he has full control over and not necessarily dispensing justice.
All right. And let's pass the same question to you, Daron, because there have also been reports of torture and mistreatment of detainees, such as the case of Eddie Mutwe, who was allegedly held and abused by military personnel. Are there measures to prevent such human rights violations? Or will there be?
That's a very interesting question. Is it, the way security organs work in Uganda is that they always work together in many times. They share intelligence together, and sometimes you realize that the army can go and execute a mission, they arrest someone, but the law does not, or maybe the law asks them that even when they make arrests as them, they are supposed to deliver these people to police, who then process them through the DPP and then put them to produce them in court in a civilian way. But that's dependent. Previously, before the court made a decision not to try civilians in a military court, previously, if it's a case that they could hear as a court martial, they would go ahead and do it. If it's a civilian case, then they would deal in the manner with the way they would deal with you. I mean, it's not the first time we've seen civilians being taken to a court martial. There were a couple of them who were taken to, who were actually taken to remand, coming to the elections of 2021. Even way before that, we've seen it in 2016 where civilians are taken to the same court. But now, you would ask yourself, how do they process these people when they get them? How do they get information out of them? Is it out of torture? You've seen people, Eddie Mutwe is not the first person. We saw people like Kapenza who alleged that it's a military personnel who tortured him. That's going to be very specific. The son of the president, according to him, that's what he said. So Eddie Mutwe is not an exception to this, including some ADs of Bobby Wine, who is also known as Chagulani. So we've been down that road. So for me, the thing is, if the army alone would stay to its mandate of protecting the borders of the country, rather than trying to do what internal affairs is supposed to do when the police force. If that clear distinction is not there, I mean, I've seen countries where the army cannot come out to quell civilian unrest, say in Kenya. You never see the army on the streets unless they are called upon. So there must be that order. But whenever we come to an election cycle like this, you're going to see the army tanks on the road. I don't know why this has to happen all the time. But again, in the army's defense, it's unfortunate. I saw the spokesperson of police on air talking about the issue of Edmutwe and say, if my boss has said that they are the ones who have it, well, I can't say anything. I think that was a little low, an expectation of having police who is supposed to know that they protect the people. You can't say that what the boss has said is, you don't know what he has said. Whatever he has said, that's what he has said. But as police, it's better that the police actually responds to the army.
All right. Now, Samuel, we have the international bodies, and also the Commonwealth. Other international bodies also have urged Uganda to uphold democratic principles. Now, do you think that the government will be able to address concerns that this proposed law undermines human rights and the rule of law? And also, if you'd also talk about, the fact that in the 2005 Ugandan People's Defense Forces Act allows military courts to try individuals subject to military law as well. Can you differentiate that with the new law for us?
The new law, which is the amendment, and the 2005 UPDF Act. So the UPDF Act was first enacted in our laws in 2005, and its target still again was the growing opposition. We were coming from a one-party system where the opposition was also stiff, and we are going into a multi-party system. So cabinet and government tried to look for a way of how to stifle dissent from the opposition. And if you recall, Dr. Kizza Besigye was the first Ugandan to be tried in that military court. The only difference is that that earlier law was very vague in terms of definition. Things like defining a service offense. Today, the Minister of Justice, Nobert Mao, is saying that it's going to create exceptional cases or circumstances where civilians should be tried. For us, we don't believe that there should be exceptional circumstances that require anyone to be tried by a military court. Actually, some of the exceptional cases we have, or offenses, are murder, because there's a life of someone being taken. Such offenses are tried by the civilian courts. So what makes any other offense so exceptional, also grave, that it should be tried by the military court? So even us from the opposition, human rights lawyers, we call upon that the government upholds civilian jurisdiction, because even the army in the constitution of Uganda is subject to civilian law. So we do not see why, if you're subject to civilian law, then you want to override and again start trying civilians in your military tribunals. We believe that's purely intended to persecute civilians and not intended to provide a safe haven for prosecuting cases that are deemed so grave to the military.
All right. Daron, now, Samuel did mention something about the elections coming up in January 2026. And with these elections approaching, how can the government ensure that this law will not be used to intimidate or even silence political opponents, especially looking at the history of military involvement in political matters?
I think the army should go back to the barracks. We don't need the army on the streets. We already have a police force that has recruited more police officers, so it has been reinforced. And also, who is in charge of the elections? It should be the Electoral Commission, and which we call now the Independent Electoral Commission. Should be in charge, should be the one guiding on who does what and what. The whole roadmap is there. So I think that the Electoral Commission in this sense should be calling the shots, calling on to police to help them and implement, provide security and all that. So if the Electoral Commission cannot assure people, the public, that there's not going to be interference of the military, because that's what I think it is. The powerlessness it has is what causes more fear, and I cannot guarantee you that security organizations apart from police will not be involved in it. I can guarantee you that the army will actually be out there because they always make a joint security meeting, they come together and say, this is how we're going to deploy that. The army is going to be able to support police because of manpower. But I'm always thinking, look, police already has its forces that come up to almost 80,000. They also have local defense forces. Those are people who are not fully police. They're not actually police officers. They just help in the manpower of police. Indeed, they're not even supposed to be armed. They're supposed to, just guide people and keep their security using batons, not even guns. That's their role. You will go up to the lowest level, which is the LC level, local council kind of security. You have the VISOs and all these things. Do we actually need police the army on the street to beef up security to help the police? I think it's not needed at all. But also, number two, what we experienced in the by-election that just happened, where there was a unit. Up to now, I still fail to define whether they are under the army or the police, which is called JAS. They are masked, and when they commit offences which the media has reported, no one comes out to claim who they are. The police does not come out to say these are our people. The army does not come out to claim that these are our people. So what is the likelihood that you have security and you'll be able to report in case of misconduct that this is a security officer who committed this kind of crime against maybe journalists or even civilians? Where we report them, will they be denied? Probably yes, because they are wearing masks. You can't identify them. And I think the fact that we saw this, we never saw it in the past elections. In the past elections, there were also a different kind of security units that came out, the anti-terrorism and others. But now we have what we call JAS. We first saw it in a by-election not so long ago, just here in March. And it felt like now we have a new guy, a new unit that is going to about screen people in case they misbehave. And now I cannot define what misbehaving is. I think they are the ones who will define misbehaving. And this is why I say that the Electoral Commission has to be in charge. Yeah. They must inform the public who is in charge of security, who they are working with, and what is their mandate. How far can they go? Rather than them just.
All right, Daron. Now, let's hear from Samuel as well. Now, you did say that the Electoral Commission, that's the independent Electoral Commission, needs to be in charge. Samuel, are there concerns that this legislation might deter opposition parties from participating fully in the electoral process due to the fear of military prosecution?
Thank you so much. Yes, those fears are not unfounded. They are actual. For as long as this law is in place, then it gives the military establishment, it gives the executive the power to arrest, detain, without trial, the civilians. As we indicated in 2020 and 2021, several young activists, mostly from the National Unity Platform, were arrested and arraigned before the military general court martial. To date, their cases have never been heard, and there is fear that once we have the same military courts in place, then there could be similar arrests of people, and then this automatically or by implication will deter people from actually even coming out to actively say that I belong to this particular opposition group, because they know once you say that, you're going to be targeted. The government has done it with the syndicate. If you followed the recent by-elections we had in one of the constituencies, the heavy deployment which was there by the military, by the Joint Anti-Terrorism Force, by the police, by the Special Forces Command, you could see that even the voter turnout was extremely low compared to the number of voters expected to turn out in such an election, and those within Kampala. Yeah, so it, by implication, once we have this law passed before the general elections, there are people who will fear to identify with the opposition for fear of being targeted by the establishment.
All right. Well, thank you so much, gentlemen, for your time and speaking on this. Daron Bartlett, journalist in Kampala, Uganda, and Samuel Wanda, managing partner, Matsiko, Wanda, and Arinda Advocates in Kampala, Uganda as well. We appreciate you for your time.